How's it going, David?
Judge, how you doing?
Hi, all right. You were here last time and somebody was like, David spoke to you. Didn't you hear him? I'm like, no, I didn't hear him.
Oh, no worries.
So how's it going?
Everything's good, Judge.
I hate it. I hate you were not able to come to the.
I wasn't able to make it.
Hey, we're now in the congressional record. Who would have thought,
Oh,
right?
Yeah,
So it was a lot of fun.
it looked like it.
And I ended up sitting next to Supreme Court Justice Wallace
Oh.
Jefferson. So it was
Yeah,
it's cracking jokes. It was a lot of fun.
good deal.
All right. Court is calling 2024 CR 008168 State versus Nathan Tyler Montoya. Can I have parties announced for the record for the state? Defense.
David Andre.
Quiet,
Woodard
please,
for
we're on the
Mr.
record.
David Andre Woodard for Mr. Montoya.
And are you Mr. Montoya?
Yes, Your Honor.
All right, you entered a plea to the lesser included offense of no contest. The court found there was sufficient evidence to find you guilty. The court deferred finding of guilt as you applied for deferred adjudication. According to your plea bargaining agreement, punishment is to be assessed at a cap of 7 years in the prison. There's a $1,500 fine. The state is opposed to your applications. This will run concurrent with County Court Cause number 734433. There should be Chapter 62 registration and no contact with the complainant. Have both parties had a chance to review the TAP evaluation and PSI report, state?
Yes, Your Honor.
Defense?
I have, Judge.
Any objections to the TAP evaluation or PSI, state?
Not this judge.
Defense?
No, Your Honor.
All right, state, you are opposed. Do you have any witnesses?
We do not, Your Honor. In lieu of the witness, we do have a letter from one of the witnesses, well entered in it states Exhibit A. I believe there's no objections.
No
And then
objections, Judge.
We'll reserve our argument.
All right, then the court will accept into evidence states Exhibits A if both parties will give me a chance to review it. All right, if you'll give that to the court reporter.
Yes.
Thank you. And if you could, I think it's marked on the inside as State's Exhibit, correct?
It is.
All right, defense, do you have any witnesses?
No, Your Honor. Only argument.
All right, then, the court will hear argument. State, you are opposed?
We are opposed, Your Honor, but we'll reserve.
All right, defense?
First off, Judge, looking at the PSI on page 2, this is Mr. Montoya's first interaction with.
Just one moment. Excuse me, counsel, if you, Ron, if you all could just move to the other end. Hi, if you could just move to the other end, we're on the record. No problem. You're our counsel. All right, we're back on the record. And counsel, what page did you say?
I'm on page 2, Judge, of the PSI regarding Mr. Montoya's criminal history.
Yes.
The only criminal history that he has, Judge, is this current case and also the misdemeanor case that's going to run concurrently with this case. Aside from that, he has no prior criminal history. He's 30 years old. At the time of the incident, he was employed at Amazon. He was working. This case was resolved fairly quickly, Judge. Mr. Montoya accepted responsibility fairly quickly. He took a plea and now we're here before the court. Since he's been in custody, I believe since May of 2024, he's had no contact with his brother who drafted the letter, I think that was State's Exhibit number A. And he's also had no contact with the young child who is his niece. Speaking with him, he realizes what he did was not only wrong and inappropriate, but it was also a criminal offense. Also, there's a TAP evaluation that is the last page of the PSI report. And the TAP evaluation does not show that Mr. Montoya has any substance abuse issues or any alcohol related issues. We are asking the court to grant his application for deferred. I know it's a difficult case, of course, to consider granting a person deferred adjudication. We're asking the court to give Mr. Montoya that opportunity, one, because he has been in custody. He's had time to reflect and to think about what he did, not only what he did, but the repercussions that happened with his niece. Looking at the PSI and also the letter that the state submitted, does look like the niece did go through some some mental health trauma. She likely would still continue to experience, but she has been doing well in school. There will be no other contact with Mr. Montoya and the niece. And we're just asking the court to consider his application for deferred adjudication. If the court does not consider that application, I believe the plea bargain was for a cap of 7 years. We're asking the court to possibly consider a downward departure and placing him in TDC for a lower amount of sentence opposed to the 7 years.
All right, is there anything you wish to say?
I do accept responsibility for my actions.
All right, just 1 second. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth, that nothing but the truth, so help you God? That's it.
Yes.
All right, you can lower your hand, state your name for the record.
Hey, Montoya,
All right, so what did you want to say?
accept responsibility for what happened, and I do take accountability for that. I do wish that they're able to have the help that they need, and that should do it. I just want to say that I am sorry for everything that has happened. I am a responsible man and will do what I can to become a better man each and every single day afterwards.
All right, I appreciate your accepting responsibility. The one question I have for you is why? Why did you do this? And the reason why I asked that question, because that's a part of, I think, an introspection, right, to yourself. So why? And I think sometimes understanding why we do certain things will help us not repeat it if it should not be repeated. So why?
Why? I believe I do need more self-reflection to understand as to why it was something that should have never been have done. Going through my own depressive episodes and self-loathing, I would say I have caused myself to go down a spiral of deep creativity, I believe.
Mhm.
However, I am able to bounce back up and to truly self-actualize myself. As to why, or that it may be because I'm also myself a victim itself, and I understand that it happens because of that kind of thing. I'm still trying to come to terms as to why, basically. I don't like saying I don't know yet,
Okay.
but it is something that I do regret. I've lost something precious to me. Understand?
All right.
If I can say.
All right. Any questions from the state?
Not necessarily.
All right. Thank you. I appreciate your testimony. All right. This is what the court is going to do. The court is not going to grant your application. The court will find you guilty. This will run concurrent with County Court Cause Number 7344433. There's to be Chapter 62 compliance. There's to be no contact with the complainant. There's a $1,500 fine, time and money run concurrent. Court will give you credit for any time served. I am unsure if the therapeutic community, if you will qualify for it. I'm going to request it for you because I think there are some mental health issues and some trauma going on with you based upon what has happened to you and based upon what I read in the PSI report that he has brothers who are in prison for the same thing. And one of the brothers was actually a perpetrator of him. And the court will sentence you to just 7 years in the prison. Is there anything else with regards to sentencing from either side?
Not with regards to sentencing, Your Honor, we do have,
All right,
Not from the defense judge.
all right. We can go off the correct. With regards to the therapeutic community, you will still have to request that. It doesn't increase the time that you're in custody, but it can help you. I would say, deal with your past trauma. You understand? I do appreciate that you accepted responsibility for this. Sometimes people never accept responsibility. Sometimes they blame other people for their actions. Is there anything else before the impact statement? Will there be an impact statement?
yes, Your Honor.
All right, and the impact statement, is that the complainant or the family?
It's
All right, then let me do this. All right, so what's going to happen now is there's going to be an impact statement, right? So you will stand over there and just internalize what is being said to you. Yes.
That's why you're like giving this letter to let you know of all the ways you're going to impact our daughter's life. However, you don't deserve to know anything about her and what she has been through. So instead, I'm writing you to tell you about the impact your choices have made to me, Tasha, and Tanya. First, me. You have caused all of my past childhood traumas to come soaring back with a vengeance. I literally felt the pain and heartache that I felt as a child when I was preyed upon by a pedophile. You caused me to question my sanity at times. Is this real? Did this really happen? You caused me to mourn the loss of a life that didn't even die. I mourn you, the you I thought you were, the you I would confide in, the you that I thought was one of the good guys. Yet instead you crept in like a wolf in sheep's clothing. My marriage went to shambles soon after finding out about the things you would do to our daughters. I lost everything in the wake of you. Second, Tasha, the pain and heartache you have caused her is immeasurable. The thoughts that race through her head daily. I can see the pain you have inflicted when I look in her eyes. She too had to mourn the loss of you. We are both in pain over this. We both question daily if we made the right decisions in life for our daughter. If we had known the signs, could we have prevented this from happening? We struggle with this daily. Third, Tanya. She too has to mourn the loss of you and question herself daily if she had only known what she could have done to prevent this from happening. I would like to think you are smarter and had a bigger heart than to do this to our family, to yourself. You could have reached out and asked for help instead of harming our innocent daughter. You really messed us all up emotionally, mentally, and financially. I hope to God that you get the max sentence, because not even that is long enough for the chaos from you that still ensues. I hope when you get out that life is miserable for you and that the courts and girls make you jump through every single hoop they've got. You put yourself in there, you did this. I have nothing more to say.
Thank you.
Monster.
Excuse me.
Hey,
What do you think? Wait, who do you think you are?
sorry.
No, and don't even act like you're over control with emotion. They're taking you back. Whose client is that?
Fine.
All right,
One of three, so I got to two now. A little more manageable.
All right, if you let them put him in a holding cell. He's overcome with emotion and he doesn't even know.
I'm a very emotional German.
Like, who's here on Alexandria? Anne Marie Alvarez? Hello.
Hi.
Hi. All right, you're requesting a bond?
Yes, for two of her cases for which she's got motions to enter.
Okay.
And we did get a reduction in County Court 2. There is a motion to enter in that clause as well.
And did you confer with the state on the bond amount?
Yes.
I signed my agreement on it.
Okay.
I don't know if she's gonna ask for us.
All right, let me find.
Would you like a copy of that motion to enter?
Oh, no, I'm just trying to find, it's this one with the agreed order. Okay. And counsel, this is back to you.
Thank you.
You're welcome. I better like that one. All right, we're gonna go on the record. Court is calling 2023 CR 10964 and 2024 CR 2671, State versus Alexandria and Marie Alvarez. Can I have parties announced for the record for the state?
Christine Brown on behalf of Alexandria and Marie Alvarez.
And are you Miss Alvarez? All right, in each of the cause numbers, this defense has filed motions to set bond. Of course, the defendant is entitled to a bond as she is on deferred adjudication in each cause number. It's court's understanding that you all have come to an agreement of $10,000.
It's actually not correct. The state would agree if we were to come to an agreement to 10,000. I am asking for a reduced bond based on her current resources.
Okay. All right, then, state you're recommending a bond of 10,000?
Yeah.
All right, defense, do you have any witnesses?
We don't have any witnesses. We just have the client. I do have her mother if she would like to testify as well.
All right. You want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yeah.
All right, you can lower your hand, state your name for the record.
Sandra Alvarez.
All right, you may ask questions.
Yes. Alexandria, when did you find out that you had this motion to enter or warrant?
Excuse me, sir, you need to have a seat.
When did you find out that you had a warrant issued for your arrest? All right. And what is your understanding as to why you have a warrant for your arrest or warrants for your arrest?
Because I got arrested in Guadalupe County. And because of that, I violated my probation in Bear County.
And what other conditions were you aware that you needed to comply with? Can I have her review the motion to enter that she
Yes.
was given?
Oh, yes, yes, parenting class and that class.
So what would you do to address those violations? Yes.
Yes, I will do that.
And who is representing you currently on the outstanding charges in Guadalupe County? Would Miss Macias, Amber Macias ring a bell?
Yes, sir.
Okay. And to your understanding, when is your next court date on those pending charges?
March 4th.
All right. And what do you do for a living right now?
I'm a hotel housekeeper.
All right.
Stapleton Suites.
What employer?
Stapleton Suites.
And how much are you making approximately?
$13 an hour.
And if the bond were set at $10,000, would that be unduly difficult for you?
Yeah, this man.
Okay, and how often do you get paid?
I get paid weekly.
Weekly? And what are your living arrangements right now?
I'm living with my mother.
Okay. No further questions, Your Honor.
All right, any questions?
No.
All right, I have a few questions. So have you ever been have you ever been diagnosed with any mental health issues?
Yes, ma'am.
All right, and have you ever used any type of illegal substance in the past? And what would that be?
Methamphetamines, Xanax, and marijuana.
All right, and what has been your previous diagnosis?
My previous diagnosis was, well, I do have a TBI, traumatic brain injury, so I don't know if that is considered a.
I mean, as it relates to your mental health.
Oh, and then, I'm dyslexic and I have ADHD.
Okay. All right, any other questions?
No, Judge.
All right, so state you're requesting the bond be set at $10,000. Why?
This is in another county. My understanding she didn't have permission to do this content, so. She's on probation in this case, she took the new cases, that's the reason that I'm requesting $10,000.
And what are you requesting?
I believe I had requested 3,000 in there for each cause.
All right, this is what the court will do. In each cause, the court will set your bond at $8,000. The court will order full GPS. The court will order that the fees be waived. Ms. Ferguson, I need a contested hearing on this case, please.
Yes, ma'am.
And if you could do it in 20 days.
Yes. I can do the 24th, Judge.
All right, is the 24th good for you, counsel?
The 24th of February?
Yes.
I have 2 trial settings on that day, so
Okay, let me see. All right. Are you able to do February 20th?
February 20th,
Yes.
I should have no issues with that.
All right, Norma, if you'll set this for contested on February 20th.
Yep.
All right, thank you. Thank you.
Thanks.
Yes.
So I just wanted to clarify, that was just the GPS, no house arrest or
No, it's full GPS.
full GPS?
Yes.
Okay, thank you.
You're welcome.
Might be a couple of more days. The clerk can look it up.
Okay, no, that's all right.
Around about that.
All right, Xavier Chamberlain. Hello.
Good morning, Your Honor.
Morning. So where are we on discovery?
Yes, Judge. With regard to discovery, the defense counsel we do believe there's outstanding evidence at this point in the form of videos and PDF reports, Judge. We'd be requesting a continuance for that, or a reset for that basis, Judge. And I'm gonna go ahead and email this morning the state with particular things that I believe are missing with regard to each of these cases.
All right, and state the discovery that defense counsel says they're missing. Do you have that in your custody?
We cannot. So I can double check, there are a number of cases, I was still going through them. If we do have them in our custody, of course, we'll find a way to get it to defense. My understanding is that we cannot. Additionally, there's an outstanding case that we are waiting on to see what's going to happen.
Yes, Judge, just to follow up on that, I went through meticulously each of the cases and evidence that is ordinarily produced is not there. There's no videos in terms of body cams, dash cams, anything of that sort, and arrests were made in conjunction with this. So I do believe that there's some things that law enforcement may have, but I'll be requesting the state look into that.
Okay.
To clarify, I'm sorry, Judge, I think I misunderstood your question. The DA's office is not.
No, that's what I mean when I say, yeah, I know it's in existence, but
Okay.
I always want to know if you have it in your physical custody. All right, I need a 30-day reset for discovery.
March 17th.
All right, we'll come back on March 17th.
Thank you,
You're
Your Honor.
welcome. Thank you. Are you all ready on McGee?
We would like to send over supplement to states.
All right, we're going to go on the record. We're back on the record in 2025 CR 0000220 State versus Jerry McGee. Can I have parties re-announce for the record for the state?
And Harrison.
Ron
Ross for defense.
Right. And state, you stated you would like to supplement the record or supplement the stipulations?
Yes, Your Honor.
Any objection?
No, we have no objection here.
Yes, and
In addition, we have a stipulation for the record.
sure. And do you all have the original stips? Were those given back to the clerk?
I don't know who they are. I never had them.
All right, the court has reviewed the supplemental. And defense, you wanted to add something?
Yes, Judge, the reports between the narratives and when they list the people involved, there's been some conflict between the different reports. They referred to my clients S1, S2, and I think at one time S3, and they've used the word P1, P2, and P3 and D1, and D3, I believe. we will stipulate that in this case, in fact, my client was the passenger in the car. He was the one that had the drugs. And I think that some of the reports refer to him as S2.
So do you understand your attorney's stipulations and do you stipulate to what your counsel has just stated for the record?
Yes.
Anything else from either side?
State.
I would just ask you, Judge, to give my client probation, and what he did was he's not done anything that was aggressive or use of aggravated. They're third-degree offenses or state jail offenses, the several different ones he had. He's testified he's had a bad year last year, mentally, emotionally. He has no prior, he has an education, he can go out and get a job. I would ask you to give him a chance on probation. And if you really want to hold a hammer on him, we didn't apply for it, but give him deferred. Really hold a hammer on it, but I don't see any reason for prison for him. I think he can get his life squared away.
All right, the court will note that he's charged with possession of drugs and not possession with intent to deliver. The court will note that there may have been some slight confusion with the police report and the way the police report was written. So the person who is in the vehicle with you, who is she to you or who was she to you?
She was just a friend.
No, I mean, you just don't roll around in a stolen car with just a friend.
If you look at it, I was actually running, I was working out, and she picked me up in that car. So I was in the car for maybe 2 blocks.
Oh, so do you want a jury trial? Because if you're in the car for 2 blocks and you just get in a car with a complete stranger, which, how old are you?
33.
All right, you're 33. I've never heard of somebody running and just picking up a complete, letting a complete stranger pick them up unless they had some nefarious things in mind. Here's the thing, these drugs were found in the vehicle, they were not found on your person. Do you want a jury trial? Because you're telling me now you've gone from I deserve probation to basically I didn't do it. I just completed my workout and I'm running, I guess, as a part of it.
I had a bag in the vehicle. I knew who she was. I had a bag in the vehicle that she just came out, and like I didn't expect her to be driving. She just came up.
No, here's the thing. We're not dealing with a stolen vehicle. What we're dealing with is you're in a vehicle with a lot of drugs.
Yes.
So what you just told me, and if I heard incorrectly, please correct me. I take no offense to it. You told me you had just finished working out. You barely know this person and they picked you up. So you got in a vehicle with them. Did I mishear?
That's what he said. That's what you said. That's correct. He also said he had a bag with him.
Yeah.
Oh.
I had a bag in the car.
So these are your drugs.
Portion of them this time.
So why do you have drugs?
Hmm?
Why do you have drugs?
I was going down on myself and using the wrong exits to do it. Getting a clear conscience now and having a time to reflect on it. I know it was a dumb decision and it's something I'm never going to do again.
All right, the court is going to find you guilty. I'm going to give you a choice. I will sentence you to 2 years in the prison today, or either I will place you on 8 years probation. Oh, so here's the thing. We don't need people in the background telling him what to do. This is not The Price is Right. All right, so what would you? All right, the court is going to find you guilty, sentence you to 8 years in the prison, suspended and probated for 8 years. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. The state is taking in consideration night mag number 751981, 751982, 751984, There's going to be field visits one time per month until further notice. There's to be no contact with, what is that noise? Do you hear that? Am I the only person hear that?
Sounds like music.
Oh, okay, all right, thank you. No problem. I thought I was, I was losing my hearing. Thank you. There's to be no contact with Savannah Lee, Devin, Devin, Sanchez Martinez. Is there to be any restitution as it relates to this vehicle?
I'm not aware of anybody.
State.
Your Honor,
Yes.
Mr. McGee is not accused of the UUMD that arises out of the same.
That's true, too.
That should be both substance and one for.
All right, there's to be no unsupervised contact with minors.
Except maybe his child, he has a child, if he has to see a child.
No unsupervised contact with minors.
So to answer your question, Your Honor, there may be restitution, but as far as we can discern, Mr. McGee is not the one.
All right, so you all are not asking for restitution. That's my question.
Correct.
All right, thank you. So there's to be no unsupervised contact with minors. There's to be 200 hours of community service restitution. The court will waive 50 of those hours once parenting classes are completed. And probation, there can be a TAP evaluation out of custody. Follow TAP recommendations. And there's to be 120 sober meetings in 120 days. Probation, is there anything else? Is there anything else that you need from the court in order to be successful?
What's your question? Like AA or NA? Okay. Every day.
Anything else you need in order to be successful?
No, ma'am, I appreciate you and appreciate the court today.
All right. Defense, is there anything else with regards to sentencing?
No, Your Honor.
All right, we can go off the record. In this court, to be successful on probation, communication is key. If there's an issue, let your probation officer know. If you feel as though the probation officer is not addressing those issues, you can come back to the court and address them with the court. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you, ma'am.
You're welcome.
Thank you, Judge.
You're welcome. Juan Aguilar. Hello.
Hello, ma'am.
Hi.
Hello.
All right, counsel. Who's the prosecutor on Juan Aguilar, please?
Ashley Jones for the state.
All right, so where are we on discovery?
Judge, I need to give the state a thumb drive. There's numerous medical reports. I can bring that thumb drive to them on Monday morning.
All right, and state, do you have all the medical reports?
I do believe so, Your Honor.
All right, is there any CPS records as well?
I believe they are, Judge.
And state, do you have possession of the CPS records?
We do have the medical records.
And Norma, I need a 45-day reset for discovery.
I don't show that we've requested CPS records. I don't have any confirmation that CPS records exist, but I will double check what was requested if so. March 24th.
All right, we're going to bring you back on March 24th. And that will be for discovery, counsel. Thank you for dressing appropriately for court. Once you sign the reset form, you're excused.
Yes, ma'am.
Thank you. David, don't be a stranger.
I won't, Judge. I won't.
Alexis Gonzalez. All right, so where are we on the PTD?
So we sent the signed agreement, we emailed it to the PTD division and we're just waiting for, I guess they have to get their signature and then
Okay,
he starts orientation.
all right. Alexis Gonzalez, if you can show your video, please. All right, Norma, I need a reset date for PTD.
March 18th.
All right, we'll be back on March 18th and your client can appear by Zoom.
Okay, thank you, Judge.
Thank you.
You have a good day.
You too. Seth McDonald. Hello.
Hi, I sent records to your coordinator to reflect what the court requested.
Yes.
I don't know if the court had a chance to review those records. If not, I brought a copy, but it got it's scratch paper, but it does say on here that they did, in fact, take off his finger on February 8th.
So state. Have you seen the documentation with regards to his finger?
I don't even think he knows.
All right, if you will, counsel, if you confer with the state to let them know what happened in this case, because there was an issue with whether or not his finger was amputated and what was going on, and that had to do with his reporting, because I'm trying to make a decision on whether or not to grant his application or not. So if you could speak to the defense attorney and they'll tell you what's on the documentation. And that may, if you can have a seat. And defense, that may make the state change their recommendations.
Okay, Ms. Jones is represented. It's not gonna change their recommendation.
And Yaya, can you make sure that the NIMAC numbers reflect that they were taken in consideration?
Yeah.
All right, thank you.
Can I put your name?
Yes.
After a spirited discussion.
Mhm.
They are not changing their recommendations.
Okay. All righty. Let's bring everybody up then. Mr. McDonald, if you'll come down, please. All right, court is calling 2024 CR 5669 State versus Seth McDonald. Could I have parties announced for the record for the state, for the defense?
Monica Guerrero for Mr. McDonald, Your Honor.
And are you Mr. McDonald?
Yes, ma'am. Yeah.
All right, you had entered a plea of no contest on September 10th, 2024. The court found that the evidence was sufficient to find you guilty. The court deferred finding of guilt because you had applied for deferred adjudication. The enhancement was waived without objection. The court ordered a PSI and TAP evaluation. On October 28th, 2024, we were scheduled, but defense counsel was in a jury trial. And I have to put this on the record. On October 31st, it was recalled for December 16th, because I believe there was some sort of competency evaluation that was filed. And also, the court was awaiting the medical records to see whether or not your finger had been amputated. And then, of course, it was recalled again and again, but defense counsel was in jury trial. And also it was called again because we were awaiting medical records. And for some reason, someone thought that defense counsel should pay for the medical records.
And I did.
And she did. But that will be taken care of.
Thank you, Your Honor.
All right, so the court, the reason he stated that he did not report and he wasn't able to report because he had his finger amputated.
Correct.
So defense brought in records to show, in fact, that his finger had been amputated. If you would like to put anything into the record, defense.
So yes, Your Honor, they sent me a packet of 400 pages, actually 475 pages of medical records. I sent the pertinent part to the court through the court coordinator, which did in fact indicate from this doctor that his finger was amputated on February the 8th of 2024. And he was recommended to be out of work or to go anywhere because of the extreme pain that it caused.
All right, and state you still wish to proceed with your plea bargain agreement of punishment being assessed at a cap of 4 years? All right, so you're changing it because you all were previously opposed, so now you're silent?
Correct.
Any objection to the changing of the plea bargain agreement to reflect that the state is silent?
No, Your Honor.
Any objection to the court writing in the plea bargain agreement that the state is silent?
No objection.
Any objection? Do you have any objections, sir, that the state is now silent?
No, ma'am, Your Honor.
So the court has received the TAP evaluation and the PSI. I previously on the record, both parties said that they had no objections to the TAP evaluation or the PSI. Is that the same state defense?
Correct.
All right. Mr. McDonald,
Yes, ma'am.
thank you for being honest with the court. Sometimes it's rare that people are honest. They still will let their attorney go try to discover something that does not exist. But in this case, it did exist. So I'm going to give you a choice. This is your only choice. There is no other choice. You understand?
Your Honor.
I can find you guilty and sentence you to 2 years in the prison, or I will grant your application for community supervision, and I will place you on community supervision for 4 years.
4 years probation.
All right, the court will find you guilty. The court will sentence you to 4 years in the prison, suspended and probated for 4 years. There's to be regular reporting by Zoom or in person, regular random UAs. Probation, is he going to be with the special unit?
Yes,
All right, you'll be reporting to the special unit. There is, and I know there are already field visits with that, so I'm not going to request field visits. There's to be Chapter 62 registration. You understand that?
Yes.
Do not miss that. Do you understand?
Yes, ma'am.
Proof of employment or SSI within 30 days, I'll say 45 days of release because based upon your charges, it's going to be hard for you to find employment. 45 days of release. Of course, there's to be no employment as a home health care provider or with minors. Probation, is there anything else? Is there anything else you need from the court to be successful?
No, ma'am, Your Honor.
All right, we can go out the record. Good luck to you to be successful in this court. Communication is key. If there's an issue, let your probation officer know. If you feel they're not addressing it, you can come back to the court.
Thank you.
And you really should be thanking your attorney for finding all of this information.
Everybody loves me in jail.
Okay, all right, have a good one.
Thank you.
Thank you.
Maybe, excuse me.
Yes, and I'll make sure you include that in your.
I will, thank you.
All right, thank you so much. I don't know, either my vision is getting worse or something else is going on. April Diaz.
Here we go.
Oh, is she currently without a bond?
Yes, Your Honor.
So does she have a warrant?
Yes, she does, Your Honor.
All right, so Ms. Diaz has a warrant.
I
Court
found-
is-
Oh, Your Honor, I had spoken to Satellite this morning, so I am prepared to walk her to Satellite if you're inclined to set a bond this morning.
Okay. All right, court is calling 2021 CR 2312 State versus April Diaz. Could I have parties announced for the record for the state
on the record, Your Honor.
defense?
Justin Fox, Your Honor.
And are you Ms. Diaz? All right, defense, you are here requesting a bond, is that correct?
Yes, Your Honor.
All right, defendant is currently on community supervision. Is there an agreement for a bond?
Yeah.
All right, and state, what is the agreement?
The agreement is to set the individual bond at $20,000. It was previously set at $15,000, previous to, putting into the case. But we're also requested an ignition unlock be, installed on a vehicle, or if she's driving at all, for that matter.
All right.
And that is the agreement, Your Honor.
All right, can you raise your right hand for me, please? Do you solemnly swear affirm? the
Oh, she
test-
can't, Your Honor, because of the,
Oh, that's okay. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, state your name for the record.
April Diaz.
I'm not talking about now. We're gonna talk, I'm gonna talk to you and ask you questions about in the past because I don't want to interfere with whatever defenses you may have with regards to the motion to revoke. So in the past, have you had any type of drug or alcohol issues?
No drug issues. I have, I've drinking alcohol, obviously, and taken necessary classes, A as well. Just this past year, though, I did stop taking and going to AA.
All right. The court is going to set your bond at $20,000. There should be ignition interlock on all accessible vehicles. There should be no driving. And there should be 120 sober meetings. And 120 days. Is there anything with regards to the bond amount? Any other issues, state defense?
no, Your Honor. I've spoken to Satellite this morning. They are prepared to take her if I could be able to walk her down to Satellite.
Oh, the deputies will have to do that.
Oh, okay.
All right, so with regards to the motion to revoke, Ms. Ferguson, I need a contested hearing date in 20 days.
Oh, Your Honor, there, as far as discovery, it's a Bell County case for her new DWI, and they're very slow in that county as far as felonies and discovery.
I'm sure somebody can get a police report from Bale County. We'll see where we are.
Okay, yeah.
All right, February 25th,
We have the police report, is this other issue, but yeah, no
Okay.
problem.
for contested hearing. If you'll make sure she has a copy of the reset form, and then if you'll speak to the deputies, they'll make sure that she is taken downstairs.
Oh, thank you, Your Honor. Appreciate you.
It is 2021-2312 in DC.
Oh, okay, I'll go take that one.